Thank you. Thank you very much. Let's appreciate Pastor Rachel. Thank you. Thank you very much for bringing us such a timely word for the Young Arbiters Society. And this is the Daystar Chapter. And as you may know, we like saying that it's Christ in us that makes our education different. So allow me to welcome all those who are visiting from other universities. Just in case you're new to this premises, in case you want to use the washrooms, you go through the back door, through this aisle or this aisle, and as you exit this building to the left, the washrooms are located there. And so time is far much spent, so allow me to call upon the next person here. And now the program is going to be self-rolling, as I'm going to invite the HOD for Public Law, Dr. Martin Olo, who will also make his comments, and invite Dr. Maurice Owor, the Dean School of Law, who will do the opening remarks, and invite the DVC, Professor Faith Nguru, to do her opening remarks, and then who will also invite our chief guests. Karibu sana daktari and namesake.
Great. I always say that it's great to be called Martin. So Martin Munyao and Martin Olo. So if you are Martin in there, please do come and we can talk a bit. Karibuni, good afternoon. How are you looking? How are you feeling? Great. Are you expectant? There is something in the house. So mine is to say this, that the chief guest, Professor Githu Muigai, allow me to say that to me he's mwalimu, Githu Muigai. Yeah? The rest we will talk about. And then Professor Faith Nguru, who is our DVC and standing in for the VC for today. I think you're always acting, eh? She's always acting, the VC. And then I also want to appreciate the Dean of School of Law. And then we have some guests that we have invited. I'm looking for Tali, Israel. It must be very dangerous to be called Israel at this time, but this man is courageous enough, Mr. Tali, Israel Tali. And then they were together with another lady called Faith Chelagat. We want to appreciate you. My colleagues from Daystar University, lecturers, students, fellow students, and others, good afternoon. I would like to do two things. One is to welcome you to Daystar University, School of Law. We are young but not young. We have done 2 graduations now. We are into our 3rd graduation. And we train, the difference between what we do and what others do is that we train lawyers with a certain Christian value. We try to make sure that people like Lord Etiang here grow out of traditional religion into Christians and therefore grow that way. Secondly, we also have a niche that we promote in our school. And for those of you who are finishing 4th year, maybe you will not have graduated, but for next year, we are launching our Masters of Law, LLM, very, very soon, hopefully by May. And we'll have a program that will be focusing on 4 areas. We'll be focusing on media and communications law. We'll be focusing on intellectual property law. We'll be focusing on medical law. And then we'll also be focusing on arbitration. Professor, you may want to know that we are taking this very seriously. And we'll have a specialization in our LLM that will be looking at arbitration. So we are serious about alternative dispute resolution. We know that the mode of dispute resolution is either civil or criminal. We know that. Or we know that you can practice around transaction lawyering and other things. But we also know that there are going to be disputes, and whenever disputes arise, even our own constitution does prefer alternative disputes resolution mechanism in order for us to settle issues early. And as Pastor Rachel was saying, that even the Bible is very clear that whenever there are disputes, we should try and settle them in the fastest ways possible. Allow me to appreciate some of the students who are here. They are coming from other universities. And I believe that we have JKUAT School of Law. Are they there? Can we see them? Can we see them? A show of hands? Yes, I will not ask you to stand up just in case you are so comfortable there. Kaiser, you're from, is that Kaiser? Saying he's from JKUAT. I can't believe it, but that's okay. Catholic University, or where for that matter, School of Law? You are very few, bana. What happened? The bus broke down or something? Okay. Please, next time we invite you, do come. African Nazarene? African Nazarene? Yes. Good. Good number. We're, of course, expecting others. I hope that next time we invite you, you'll come again, and make sure that after this, you go and tell the others that, hey, it was good to be there. Of course, they are the hosts, Daystar University students. The hosts, led by quite a few characters I saw here. And good. The moot court was good. I think that was some good display of skills there. Keep it up. One more thing, and I'll be down because we have our time is well spent. We are in that mood of public lectures. So just in case you want to know, on 1st of March, in the afternoon, we'll be having a lecture. There's a professor who is visiting from the US. He's called Professor Inazu. He's a theologian, he's a political scientist, and he's a lawyer. So he'll be talking to us in the afternoon. We will send out a flyer, so please look out for it. If I were you from where, you will now come with a few others. So please do talk to our other colleagues. Now, let me appreciate Marty and your team, particularly for organizing this. The Young Arbiters Society. Young, upcoming, talented people wanting to build up your talents, attracting our mwalimu here so that he can also talk to us. So, with those remarks, I would like to say that we are all ready and set, and I would like to welcome the Dean, School of Law, Dr. Morris Juang Owur. Others call him sometimes Morris Olo, others call him all those confusions, but he's Dr. Owur. Karibu sana, Bwana Dean. Yeah, let's appreciate him. Let's appreciate him.
Thank you very much, MC, Dr. Martin Olo. The acting Vice Chancellor, Professor Faith Nguru. Professor Githu Muigai, Senior Counsel, Elder of the Order of the Golden Heart, Attorney General Emeritus, colleagues, academic and non-academic, students from the various universities, students from JKUAT, African Nazarene. Are there students from Mount Kenya as well? Queer. Good afternoon and shalom. I would want to make a few remarks. And first and foremost, I would wish to say that public lectures are unique opportunities for acquiring new knowledge. We appreciate that you have lectures in class, but public lectures are different. They are different in the sense that they bring persons with experience in specific areas. They bring to you people who have a specialized knowledge, and therefore you are able to tap their knowledge, their experiences. And public lectures can be useful in the sense that they could even determine the area of research that you decide to settle on. It is possible that your dissertation topic may crystallize after a public lecture. Public lectures may also strengthen your knowledge base in a particular area, particularly when you hear from persons who have distinguished themselves in that particular area. And for that reason, I would wish to commend you for coming for this public lecture. It is not a waste of time. It is not a waste of time. And this particular public lecture is unique because of the guest lecturer. The public lecture is in the area of arbitration. And our guest lecturer is a person who is distinguished in the area of arbitration. He has practiced nationally and internationally. He has appeared before international tribunals, the International Center for Settlement of Investment Disputes. And for my students of public international law, you should be able to now appreciate that here is a guest lecturer who has appeared before the International Court of Justice. He has also appeared before the International Criminal Court. So therefore, we have a unique guest speaker. You do not get Professor Githu Muigai appear as a speaker, just like that. It is an honor, it is a privilege to have a guest speaker of his caliber. You are also aware that he has also distinguished himself as a law professor for many years, with many publications to his name. And in the area of litigation, he has practiced law. And you are familiar with the presidential petitions. He has appeared in several presidential petitions. So therefore, he is not just another public speaker. Unlike the lizard in Chinua Achebe's book, Things Fall Apart, I will blow his trumpet on his behalf. The lizard in Chinua Achebe's book blew his own trumpet when the lizard jumped from the Iroko tree. And the Iroko tree is the equivalent of our Mugumo tree. So when the lizard landed on the ground and landed unscathed, he wanted to make the whole world appreciate that he had achieved such a feat. So he was blowing his own trumpet. But in this case, I will blow Professor's trumpet. I will blow his trumpet. Now, I would also wish to state that the choice of the public speaker in this case has been deliberate. The choice of our public speaker has been deliberate. I would wish that you look at the CV of Professor Githu Muigai. It is in a summarized form, and it is 15 pages. Summarized form, okay? 15 pages, summarized form. If you look at that CV, then you can begin to role model. You can begin to set standards for yourself. There are 3 areas which one would want to look at in that CV. There is the experience he has as a law lecturer and the publications he has done. And one is impressed by his qualifications and his publications and his contribution to the academy. You then may want to move to the second area, which is the area of litigation. And in the area of litigation, again, he's second to none in the area of litigation, both national litigation and international litigation. You may want then to move to public office. He has risen to the highest office as the chief guest, as the special advisor to the president, legal advisor to the president. And hierarchically, he would be in the top 4. But what that means is this, young people. If you wash your hands, as Chinua Achebe would say, if you wash your hands, if you distinguish yourself, you can dine with the kings. You can eat with the elders. If you distinguish yourself. And you have the opportunity. You have the opportunity to be the best version of yourself. In Daystar this year, our theme is transformed encounter or transformation. And I'm saying that you have the opportunity to transform yourselves. Professor, in his 4th year, he was the best student in that year. And he also was in terms of what would be GPA, he scored the highest during his year and won many awards from various legal firms. So therefore, you can already begin to see him as a role model. And it is no wonder that many years later he is where he is. It is not by accident. You must put in the work. You must put in hard work. You must do the heavy lifting. And when you do that, then the sky would be the lower limit. So I would wish to encourage you to give your very best. Give your very best. Make the library a place close to your heart so that you're able to get as much as possible. And therefore, in conclusion, I would again wish to recognize and appreciate our chief guest, Githu Muigai, for finding time to be with us here today. And we have whispered to him that if he agrees, if he permits, then he could be coming back to Daystar if when the schedule permits, to have guest lectures. And those guest lectures could be in the area of constitutional law, in the area of international law, in the area of arbitration. So we would now wish to form a closer partnership with Professor Gidhu Muigai if he permits. And with those very many remarks, I would again want to thank you, to commend you for coming here. It will not be a waste of time. It is possible that you can transform yourself through this guest lecture. You can be the best version of yourself. And with all that, God bless and enjoy the rest of your evening as we hear the guest lecture. But in the meantime, I would wish to invite our acting Vice Chancellor, Professor Faith Nguru, to invite Professor to make her remarks, and then in turn to invite Professor Gidhu Muigai, Senior Counsel. Thank you.
Thank you very much. Good afternoon, everyone. How glad I am that I wore this jacket. I would have worn my yellow, bright yellow one, or bright pink, or one of those. But fortunately, I got to blue so that I can approximate yourselves. I wish to once again welcome students from universities that have been mentioned. Thank you very much for coming. It's always a joy to work together. And I also come at a time when I'm celebrating, not my birthday, not my wedding anniversary, but that my daughter passed the bar exams yesterday. I am really happy and thankful to God for that. And I'm saying this to encourage you that it can be done by 21, 22, 23-year-olds, and that you can start at that age and excel. So the books that the dean is talking about is very, very important. And the support. Parents may not fully understand what it is you are studying, what you are saying, but we are there behind the scenes supporting you, and we want you to succeed. So I wish you well. What we have this afternoon is an intergenerational kind of a gathering, a very, very important thing that is happening. You may not really appreciate, but the fact that we have Professor Gidhu Muigai here, and he has been introduced in an elaborate manner, the fact that we have others on the line that he is mentoring, as he was mentored, is very, very significant. So let's not take anything for granted. It's a joy, it's a privilege to have all of us here this afternoon. Already we have mentioned the importance of public lectures. Please come to all the ones that will be lined up. And this particular topic that is being covered, we have at Daystar many courses in arbitration, so you get quite an exposure, and some of you already have that exposure, and I want to congratulate the team that was here. It is so nice to hear people speaking sense. It's beautiful to the ears of a DVC academic to hear students articulating the matter at hand with such confidence. Congratulations. Let's give them another hand. So I would want to once again recognize the lecturers who are here, colleagues who are here, so that we learn together. Tali Israel Tali, interesting name. And thank you for coming to give that guidance to our students. Finally, before I officially ask our chief guest to come and address us, the Young Arbiters Society Well done. There's a lot that is going to happen, and we are looking forward to your organizational skills. And you can see, at least in Daystar, we have all the people coming in to lend a hand. Students in communication, the production unit, thank you very much. People in other areas, because I believe you are starting to see law in context, even as we study, or as you study with the other colleagues. So it's my great honor, Professor Idhu Mugai, to ask you to come to the platform to address us, to learn again from you. You've been here before, and we have already mentioned that we'd like you to keep coming. So let's give him a hand clap as he comes. Thank you very much, and God bless you as you share.
Madam Vice Chancellor, I want to thank you for inviting me again to this your very esteemed university that it's been my privilege to visit before and to talk to the academy here. My very good and dear friend, the Dean, Dr. War, with whom I have served in many capacities in trying to shape legal education in this country. Thank you for inviting me. As you know, it didn't take a lot of persuasion. When you were in another educational institution, again, I had the privilege to come there and support your great effort to create the next generation of lawyers. My own student, Dr. Martin Olo, my other student, Dr. Ben Musau. This is the sort of talent that it's been my privilege to unleash to the world. Tali Israel, Tali is the latest to leave my stable. I don't need to say anything. His judging of the mood speaks for itself, and I want to congratulate you that you have started on this journey of giving back to the profession and the academy, and I wish you well in the rest of what I think will be a brilliant career in the academy and elsewhere. I do not want to remain very fixed to the topic that brought me here today, because I know that already most of you are familiar with the topic of arbitration. Some of you may be taking courses relating to it, but it is my entry point this afternoon to allow us to have a little dialogue about the place of law and in our country, and the future of law in our country, and specifically the future of the various opportunities that exist within law. The reason I cannot fail to show up for a public lecture is because I remember my own time at the university, and the richest learning that I had was when people came from the city down to the university. There was only one university. Now there are many good universities, including our very own here. And they would come down to the university to Taifa Hall, and we would have a whole afternoon listening to the most controversial figures of the day, I will not mention, since that is a different topic for another day. Now, law in this country is at a crossroads. Too many things are happening about law, and the legal profession. And I think as young scholars, this must be a time in which you question yourself, did I come to the right profession? Will I have a good career? Will I have a future? Will the profession have a future? I was speaking at lunchtime with some of my friends and colleagues here, and somebody mentioned that yesterday, a very senior counsel, it turned out a senior advocate. You know the distinction, or do you? Do you know the distinction between a senior counsel and a senior advocate? Yes. John Kamenwa is a very senior advocate. Firoz Noroji is a very senior counsel. So there is a difference. Now, there was, my interlocutor mentioned that a very senior advocate said yesterday that the legal profession is saturated, that there are 4,000 lawyers or something like that, and that we should be concerned about the number of people coming into the profession. I do not subscribe to that view, although I could have held it many, many years ago. I suppose the younger you are, the more vulnerable you are. I think that the expansion of the legal profession is intended to grow in leaps and bounds because the very nature of law is changing in a very dramatic way. When I left law school as a young graduate, I found lawyers who could practice law with a copy of the Penal Code, the Criminal Procedure Code, and the Civil Procedure, Criminal Procedure, Civil Procedure. Not even the Evidence Act. And that was a total and complete practice. Because during those days, especially in rural courts, there was very little by way of complexity of legal problems. Today, a lawyer who does not seek to understand the intersection between law and many other complex disciplines. For example, there is no way you're going to be a competent commercial lawyer unless your understanding of economics in general, finance in particular, and accounting and many other related disciplines is very good. Not good, very good. Am I right, Ben? That's a fact. There is no way. There is no way you're going to be a lawyer around projects unless you can understand the very fundamentals around engineering, all forms of engineering. Because, and we will talk about this, I listen to many construction disputes, and I can tell you, there is no way you can practice as an arbitrator or as counsel before construction tribunals unless you have internalized the intersection between law and engineering and quantity surveying and architecture and so on. The lawyer, the penal code lawyer, civil procedure lawyer, and so on, his days have come and then they have gone. Equally, and this is the opening of my comment about today's lecture, because of how complex legal problems have become, ironically, the capacity of the ordinary court to resolve complex problems, especially of a commercial character, has diminished. Now, in some jurisdictions, like the United Kingdom, for example, they have invested a lot of money and training to create a commercial law judiciary, which is very, very, very well resourced. And that is why London is a center of international commercial dispute settlement, both within the arbitration sphere and within the court system itself. And we will discuss this shortly. Commercial arbitration is as strong as the commercial courts are, because the commercial arbitration must be supported by very strong commercial courts. Because although the takeoff point is that courts should not interfere with arbitration proceedings, there are very clearly set out areas where courts must support the arbitration process. And where the judiciary is weak, arbitration is weak. Because either the judiciary is interfering in the arbitral process or is incapable of timeously providing for the enforcement of arbitration awards. Either way, the process suffers. And this is one area that I believe we in the arbitration business have been talking to the judiciary about. I was talking to somebody earlier today who will remain unnamed, who says, I filed an application urgently before the Commercial Division of the High Court of Kenya to arrest an arbitral process that had been commenced illegally. We have been waiting for a ruling for 9 months. When people tick the ease of doing business, wherever they are in the world, they ask, how long does it take to resolve a commercial dispute in Kenya? Answer, it depends whether you go to court or you go to arbitration. Supposing we go to arbitration, answer, it can be anywhere between 3 months and 9 months or thereabouts. What about if there is court intervention? That is the fork in the, and the correct answer would be, it can be anywhere between 1 year, 5 years, 7 years. Yesterday, I was asked to lead a team of lawyers who are arguing a very law-defining case in the Court of Appeal relating to the proper scope of review by the courts of an arbitration award. This case has been ongoing, I think, for the last 9 years. Arbitration, High Court, Court of Appeal, Supreme Court, go back to High Court, and that is where we are, 9 years. That is very bad news. The purpose of international practice around arbitration is to expedite the resolution of disputes. All right? So that disputes are timeously processed. We remove backlog. And I'm always talking at international arbitration events and saying to my colleagues, we will kill our profession if we become another court with more complicated procedures, with delays, with adjournments and adjournments. Because the reason people come to arbitration is because I want to know. The university has terminated my services. That's okay. But what am I owed? The university is not speaking very loudly about what I am owed. And I want to know, is it 1 million, 500,000, 100,000? What is it? So that I pick up the pieces of my life and continue. But if 3 years, 4 years, 5 years from when I lost my position, I am still before an arbitrator, that is not what arbitration was intended to be. The other issue is about costs. Costs. We need, the purpose is to keep justice affordable. Justice must be affordable. Arbitration was intended precisely to do that, to create affordability in the sector. We will ask ourselves before we finish whether that has become the case. Some people would say, no, arbitration has become quite expensive. Arbitrators cost a lot. I can tell you, international arbitration is expensive, and we should not make local arbitration expensive. The other one is confidentiality. When you go to before an arbitration panel, the door is locked. It is just the opposing party and the other party, their legal advisors and other representatives, and then the panel. That is intended to contain the dispute, especially commercial disputes. Very few corporates want the disputes they are involved in the headline of the Daily Nation. Because that's not how you do business. You cannot afford to have the headlines disclosing who you are fighting with. Yesterday you were fighting with a former employee. Today you are fighting with the bank. The other day you are fighting with an insurance company. If you are in the front page of the Business Daily, people begin to have an opinion about the kind of corporate you are. Arbitration offers confidentiality. So within the four walls of the room, you can have confidentiality. But the other thing that a good arbitral tribunal should do is be efficient. And we saw that, the dispute that we listened to, you could see the efficiency of it, the efficiency of the tribunal itself. Very few questions, but very pointed questions, very good responses, pointed responses. Memorandum has been filed, submissions have been filed. It's not an opportunity for pontificating. It is an opportunity to highlight and draw the tribunal attention to specific things. But in international practice, arbitration has become particularly attractive because of the nature of the disputes that come to international tribunals. They are complex arbitrations relating to multiple contracts, multiple parties, and requiring commercial efficiency. And therefore, if you look at, and I challenge you to read the defining case that came down from the High Court in London at the end of last year on Nigeria versus some paper investors. And at some point, the judge there is saying that he's beginning to wonder whether arbitration processes are appropriate for investor-state disputes. That is a very serious thing. It means that there is something going wrong here that we should arrest. And read that case. It's available. I'm sure, Prof, you'll be happy to supply it. It tells you also about the problems we are facing here in Africa, about talent, about capacity, about our own preparedness. When I went to Sharia House, I found that the policy of the government of the Republic of Kenya, each time it had an international dispute, was to say which international law firm can represent the government of Kenya, by which they meant a law firm in London, in Paris, in New York, etc., etc. And then I said, now, this doesn't make sense to me, because if we do this, are we going to do it ad infinitum until the end of time? Where is the capacity that we are generating so that tomorrow we can do the case for ourselves? I said to myself, this model is very wrong. And one of the changes I made, it's a very good office to work in. unless you are not a man of bravery, and you have to ask people what you should be doing, you have nobody to ask. It is yourself. So I didn't go to ask anybody, what shall we do? I decided what we were going to do, and that is what is being done today. And it was this. For as many times as the government of Kenya was sued, we would invite local law firms to express an interest in working with us, not taking the brief, working with the Attorney General's office to defend the case, including inviting an international law firm to work with them. So we reversed the order. So Kenyan cases today in 2024 are defended by the Attorney General, supported by local Kenyan counsel, and, if deemed necessary, with the assistance of. So we stopped shipping cases to, and I think today, the quality of Kenya's preparation in some of these cases is now legendary. We won, when I was in Sharia House, we won 7 cases, not losing, winning case after case after case. And our reputation grew, and word went to the market that if you are an ambulance chaser looking for cheap litigation to win quickly over a banana republic, it is not Kenya. Those people are bad. They fight very, very rough. So you are better off going to Equatorial or something or other, but not Kenya. Now, so what is the point there? I think that we ourselves as lawyers, we must take ourselves seriously. And when I listened to the moot court, I was very, very encouraged. I was very encouraged. Because you can tell that each one of the mooters spent time preparing and taking a command of their case. When I went to that august house, I discovered that each time the attorney's office was involved, or some local lawyers, 9 out of 10 of them had never read the file. They had no interest. They were farming out the brief to some foreigner. And then they would buy an air ticket, and then get some per diem, and then go and shop. And then I said, no, this is not on. And we trained young, energetic lawyers who write a brief, and you read it, and you say, I have worked with barristers, for example, in the UK, who read a brief written by a young state counsel in Sharia House, and they say, this would be an A barrister in London any day. You cannot improve on this capacity to isolate the legal issue, to isolate the facts that impact on this issue, to isolate the doctrines called in by the matter, and to suggest the ways of resolving the dispute. And that's important, and I think in your generation, it's going to be more important because you are competing with a bigger group. The truth is that in our lifetime, in your lifetime for sure, the entire legal market in the 7 countries of the East Africa community will be one market. So, and I have been to Rwanda. I have done arbitrations in Rwanda. I've done arbitrations in Tanzania. I've done arbitrations in Uganda, and so on. And it is one market. and the employer will be able to choose from the best. And I can tell you, the best is here. But you can't afford to fall asleep on your feet. The best is here. The education system we have here on legal education is very robust. I had the great privilege last November, one of my old young students, it has been made the head of the Africa practice in the largest law firm in London, by which I mean a solicitor's firm, half Americanized, half whatever. And she said, you must come, and because they are having a dinner for me, and I want you to speak. So I went, and I spoke, and she was very, very good. She's in charge of such a huge practice group covering the whole of Africa. You trained her at Kaplan and Stratton, Ben, Miss Mbaluto? Yes, my chest was so full out when I was asked to say something, because I thought all these people must be saying, if this girl is so clever, surely her teacher must be. So I was trying to feel the shoes. And what am I saying? Is that the opportunities are so many, and our education here is so good that you can, if you take yourself seriously, you can compete as against the whole world. And I would like to hope that the majority of you here are not thinking, let me finish quickly, I go to the School of Law quickly, then I return to Kitui quickly, so that I settle down in Kitui, because now I can see all those people. I'll overtake them very quickly, and then I'll be the best lawyer in Kitui, and then I can live happily ever after. No. Kitui is where you go to retire. It is not where you begin your career. And we'll discuss that on another day. Now, so I've already talked about costs and why we as arbitrators should be concerned about costs. I have talked about confidentiality and why we should be concerned about keeping. And I think, I do not exaggerate, when I was studying professional ethics a lifetime ago, it was emphasized over and over and over again. You shall not disclose any information that has come to you while acting as an advocate, received by you in the confidentiality of the client-advocate relationship. I wish I would say, ladies and gentlemen, that your generation is adhering to that very basic ethic. Now, I think partly because of social media and the pressure that social media has brought in all our lives, So I don't want to shame you by saying that young people are on social media. No. My mother-in-law is on TikTok and a very happy member of the TikTok community. And I see her burst into laughter from time to time. And I can't ask her, Ma'am, what have you looked at? But social media has brought incredible pressure to all of us, but especially to professionals. So that I think half the people that I see on the platform formerly known as Twitter, which is a very important source of news to me, because I have on that platform subscribed to every major newspaper in the world, to BBC, to CNN, to Al Jazeera, and so on. So it's an important platform. But what our African brother, Elon Musk, has done, is instead of you being left to follow the people you want, he has brought another sub-platform there where he picks people he thinks you should be following. And from time to time, I see lawyers, both local lawyers, and the sort of things they say and the sort of things they write are horrendous. And sometimes I thank God that my teachers, most of them have passed on, so they don't have to see this, because they would have had a heart attack and died anyway. It is good that they died peacefully, not knowing that this time had come. So I have seen lawyers, and not junior ones, write a demand letter to somebody, then put it on Facebook. We really must bring back the profession. And we, as young arbitrators, must be particularly concerned about reputation. An arbitrator is picked by the parties on the basis of his reputation. You cannot have a reputation if on every social media platform you are being quoted on every conceivable subject under the sun, including where you had your lunch and how many bottles of sophisticated wine were available. Today, when a lawyer says to his client, wherever he is in the world, we should go to arbitration, the arbitration provision is binding, and the client asks, okay, so how will the tribunal be picked? Say we pick one member, the other one picks the other member, then the two of them pick the chairman. The first thing the client does, or the client's advisors, is to go to Professor Gugu. And they ask Professor Gugu, have you ever heard of the Dr. Martin Olo? Now, Professor Gugu is what we used to call in my time, is a mujuaji. He's a mujuaji. Everything you've ever said, everything you've ever written, every photo you've ever taken, Professor Gugu knows about it. So the client is sitting in South Africa and is calling his lawyer and saying, is this the fellow you are saying we appoint as an arbitrator? He seems to spend all his time in these nightclubs in Nairobi. He's posting his whiskey, he's posted his gin. Surely, find us a serious man or a serious woman. It is very important, ladies and gentlemen, for you to calibrate your brand. Calibrate your brand. Be very careful. The temptation is there to compete with the people you were in high school with. And therefore you want to show them, this is me. Which is the best bar in Nairobi now? Since I live in the villages, I don't know. Anyway, let us say this is me in the best bar in Nairobi, and this is my bill, which I have just paid, which is 100,000 shillings. The internet never forgets. If you want to go somewhere, if your eyes are telling you, Dr. Law, I don't belong in Nairobi. My final destination is World Bank Group, Washington, D.C. Then be careful what you are putting on social media. The first time you apply to be an intern at the World Bank, they run a check. And if the first photograph they see is of part of your anatomy stretched out, I don't think you can take issue with them if they conclude that part of your anatomy is spread out that way and then photographed because it's the only thing you bring to the table. Because if you were a lawyer, the photograph that should be on the internet should be showing you at your desk with your computer and your law books and your fountain pen. But if the first thing they see are the muscles, yes, and a big cigar and a whiskey, I think they will be able to say, this is not the man we are looking for. This is the man they should find for a modeling stint, something to advertise good suits, good cars, good cigars, things like that. So an arbitrator must have a brand. People must think of you as the learned one, the wise one, the calm one, the rational one, the just one. If that's what you want to be, if arbitration is your destination, your brand starts now, not then. Okay? And there are many people in the arbitration market who show up for the arbitrators, but they have no work going to them because that image has not come through. The image of being fair, of being just, of being rational, of being patient. The flexibility of the arbitral process is another thing that is going towards. Court is very rigid. Civil procedure, court and rules, the Evidence Act, they are all fairly rigid. The arbitral process is quite, you go to the arbitrator and you say, look, Mr. Arbitrator, this is a 1 billion shillings dispute. It's a 1 billion shillings dispute. We will not be calling any witness. It is a documents-only arbitration. We want you to look at the arbitration agreements and we want you to look at the transaction documents in which the arbitration agreement is embedded. And we want you to determine the following 2 issues of law. And that's flexible. Okay? There is another one in which we say, I was involved in such a preparation last night because the tribunal is in London. Some of the arbitrators are from other countries, and the state parties are different. And last night at this session, we were arguing about of the 46 witnesses that the state party, I'm representing a government, has intimated they will call in their case, how many of them must be physically present in London when the arbitration kicks off next month? 46. Do you know how many we finally agreed should be in London? 6. So where are the 40? Of the 40, 23 or so will be interviewed via video link. Of the 23 others, whatever they aver to is not contested. That is the flexibility of arbitration. That's the flexibility. How long will it take? It will continue every day for 2 weeks. Every day for 2 weeks, from 9:30 in the morning to 4:30 in the afternoon with an hour lunch break. What will happen on the 14th day? It will finish. Whether we have finished or not is our problem. The time allocated is 2 weeks. So, if you are not moving fast enough, we sit on Saturday. If it's not moving enough, we sit on Sunday. But on the 14th day, the arbitration will come to an end. That is the flexibility. As opposed to going to going to Milimani Court, saying to the judge has a course list of 30 matters, calls all of them, and at about midday, he says, Mr. Israel, I'm now ready to hear your matter. How many witnesses do you have? 5. Let us start and see how far we can go. First witness, you lead him through the evidence. It's 12:30, 1:45, and the judge says, Mr. Talley, shall we adjourn for lunch? Shall we start at 3? 2:30? 3. Say 2:30. Okay, 2:30. So she comes in at 3. Say, continue. The witness is still on the stand. So it's now 4:30. Would this be a good time to break? No. This matter was listed for 1 day. Let me now give you dates we are in February. My earliest dates are now in November. Is that okay? Oh no, I have something. Is it okay? You cancel, okay. January 2020. Why arbitration is more attractive is that these 14 days are cast in stone. I remember one of the things we were discussing last night about my forthcoming arbitration is one of the counsel on the other side said, okay, my star witness will not be able to come to London. So we asked why. Because he had a heart attack. And he's in ICU. So what do we do? Well, we say, look, it's your case. It's you to do what you want to do with your witness. We are sorry he's in that state. But that's it. Now that witness is struck off the list. We are moving. The flexibility of it is we are moving. The only application he can make, which he didn't make, is can I substitute his testimony with somebody else? He didn't. Meaning down the road, he's waiting to be able to say, you know, so-and-so had a statement. I want to put in the statement. And then we will say, so what is the weight of that statement? He's not here. He's not coming. He's never expected to come. So what's the weight of that statement? How shall we test the veracity of the things he has said there? Between you and me, witnesses do get into all manner of physical problems as the case draws near. Because the day of writing the statement was a nice one, a relaxed one. The day of being asked, is this true? That is not a good day. So we're talking about why flexibility makes arbitration attractive. What is the warning? Don't try to be a judge. I want you to behave like Israel Talley here. Flexible. Arbitrators are beginning to convert arbitral tribunals into courts, including my lord. I said, no, me? A lord? A lord of where? Huh? So an arbitrator must be flexible. Make it possible. The first thing I do when I'm an arbitrator, you come to my chambers, we all get settled, is that I invite anybody who wants to remove his jacket to do so, to hang it up there, because I have already removed my jacket, and to enjoy the bitings that are in the room, and just basically feel we've come to ask this gentleman, in the hope that he's a learned man, to tell us who is right here and who is wrong, and how, or are we all right, and how can that be resolved? So we must be informal, not formal. Arbitration is informal not formal. And I read, and I think in one of the areas I sit, which is ICSID, the World Bank arm of dispute resolution, I am shocked by how learned the decisions are, and I don't support it myself. It's like an academic essay. And this is because I think far too many professors are involved in that process. I personally believe that an arbitration award must be simple, must be clear, must be intelligible to the parties, not to their learned representatives, to the parties. At the end of the day, when you say, I find that the claimant partially succeeded, he must understand what is partially succeeding. I therefore, from his claim of $10 million, I award him $2 million. He must understand your reasoning. Why? Okay? And that is, the reasoning is not contained in saying, Lord Denning said. Surely, Lord Denning must have had a very good reason for saying. Yeah? And the East Africa Court of Justice, in the case of was said. In fact, one of the areas I criticize law professors today is that they don't teach a course which I was taught by one of the most distinguished law professors of all time in all universities that I had the great privilege to attend, to visit, Okoth Ogendo. He used to teach a course called Legal Methods. Has it been scrubbed, Dean? It is still there. Yes, and I remember him when I was in first year saying, we do not cite cases to fill up the brief. We cite cases for the proposition of law that they contain. Okay? So, no matter what the judge said, it is of no consequence. What is of consequence is the ratio. And the ratio itself has a ratio. Okoth used to call it the ratio of the ratio descended die. The reason of the reason for reasoning. Today, don't tell them that I said so. But even the Supreme Court, if you read a judgment, you find several pages that says, and the Supreme Court of Canada said, and the Supreme Court of New Zealand said, and the Supreme Court of India said, about what? About what? Whatever they said is of no consequence unless they are talking about something that touches on Kenyan law. If a statute is in parliamentary, it is important. So you can be able to say, the Penal Code of the Republic of Kenya is in parliamentary with the Federal Criminal Statute of Australia, for example. And Section 5 of the New Zealand statute states this. And Section 23 of the Kenyan statute says this. Therefore, in interpreting the New Zealand statute, the New Zealand court said, therefore, what the New Zealand court said is relevant to interpreting Section 23 because it has not been interpreted in Kenya before. But you cannot just fill the entire opinion with what other people have said in general. The US Supreme Court said the right to vote is a very fundamental right going to the heart of every democracy and must be protected by law by all means possible. What is that about? Do you need the US Supreme Court to tell you that? No. The framers of the Constitution of Kenya, that is what precisely, unless you are decorating the judgment or trying to demonstrate learning, it is irrelevant. Yeah? So, I believe that an award should be simple, straightforward, devoid of a lot of clutter. And clutter is brought to the award the minute you start showing. And this is worse with non-lawyer arbitrators. As you know, you can be an arbitrator without being a lawyer. Actually, maybe 40% of the arbitration profession are non-lawyers. Majority of them, quantity surveyors, engineers, architects, and so on. And the majority are very good in resolving construction disputes and so on. But precisely because you are not a lawyer, you can carry a chip on your shoulder. Each time you say something, you go looking in Pakistan for a case. You don't need it. You should be short, precise, concise, and intelligible. Now, I have already talked about complex arbitrations and why arbitration is a more serious format for resolving. For example, you can imagine if you have a complex transaction like the ones my friend Ben works on about developing infrastructure. Say you are building a port like the port of Lamu. You can imagine how many different people are inside that project. Yeah? And don't forget, they are the financiers, they are the insurers, they are the actual contractors of various things, because various things are being done by various contractors and subcontractors. There are various professional advisors, quantity surveyors, architects, electrical engineers, mechanical engineers, all manner. If that dispute explodes, it is such a complex dispute with so many parties that the only efficient way of resolving it is within one roof. And arbitration is the most efficient way to do that. There is no other way. There is no other procedure. In fact, even if we were to say in a commercial court, we give dedicated 30 days to this case, it would not move beyond phase one. So the trends internationally, globally, is to take all these sort of complicated disputes and bring them under one roof and resolve them under arbitration. That's why I think that this, even in Kenya, is the growing trend. There is more and more of this stuff coming to arbitration. If you want to know how busy this process is, remember, in Kenya we have the Chartered Institute of International Arbitrators, which is probably the original body. We have ICC. ICC is not the International Criminal Court. Who knows what ICC is? The International Chamber of Commerce, it's an appointing authority here. The Permanent Court of International Arbitration, it appoints from here as well. ICSID appoints from here. And then we have my very, very, very own special child, the Nairobi Center for International Arbitration, that I worked on when I was working for the people of the Republic of Kenya. And it is a very important center. And I would challenge your chairman of the Young Arbitrators, please organize a visit to the Nairobi International Center and tell them that I said they must receive you and spend a day there. It's Kenya's own way of trying to grow this. They will give you the statistics. By the way, you can find them online. The Nairobi International Arbitration Center, you will find them online. If you look at the case law, it's been growing year on year since when we set it up. And it is now one of the more respected institutions in this part of the world. And I think it can only get stronger and stronger because that's how people want this dispute resolved. What are the last topic? I want to talk about three small issues so that we can all go home. Number one, am I saying arbitration is becoming the new trend of resolving these disputes, and it is very good, it has no problems, and all of us should be taking all disputes? No, I'm not saying that. We have our own problems in arbitration. I have alluded to one of them. I have said that there is there is a judicialization of arbitration, which is not good. A judicialization of arbitration. People came to us to resolve problems quickly, efficiently, cheaply, and we are now trying to behave like courts. We are going back to not being expeditious, being technical, being lengthy. That is wrong. That has to be arrested very quickly. We must arrest the trend to judicialize arbitration. We must we must arrest the process where it becomes expensive. You go before an arbitrator and he says, Dr. Law, what's the dispute in this matter? And say, Mr. Arbitrator, sir, this is a dispute between my client and my colleague's client over a 50 million shillings property that they had bought. If the arbitrator starts by saying, okay, Dr. Law, I hear you. My fees in this matter, my deposit will be 5 million. You are already headed south. You are fighting over 50 million. The arbitrator wants a deposit of 5 million. So when his final fees comes, it will be what? 10 million, let's say. So a fifth of the disputed amount is his. Wrong. Wrong. We must make arbitration affordable. Yeah? The arbitrator must charge per hour so that he can justify what he's doing. He says, I'm a very senior arbitrator. My charge out fee is 25,000 shillings an hour. Then the parties say, no, sir, the parties are happy to pay you 20,000 an hour. Now, let us work out how many hours. If we don't go that way, if we go the way of litigation, and I have seen many advocates in this city, I think my friend Ben Musau will confirm, who seem to tax every bill against every client. How is that possible? How is that possible? Don't you want to have a relationship with the client that opens up? I used to tell my students when I taught professional ethics, do you want to take 10 million shillings from your client because it's in his client's account and you fight? Or do you want, for the rest of the 40 years that you intend to practice, do you want to be receiving 2 million shillings a year from this client? Then you will be 90 million shillings. Is that rocket science? No. You want people to stay with you for the long run so that you can have a healthy relationship in the long run. Not a pickpocket relationship where you pick his pocket and then run away. So we need to be careful about costs. We need to be careful about time. We need to be careful about judicialization. Let me speak about a second and final aspect of something I had mentioned again. The arbitration profession and the courts need to be talking all the time. Because if we are not, the court becomes part of the problem, not part of the solution. And I've already alluded to, you go to court, you have an emergency application, the judge hears you, 6 months later, there's no ruling. Yep. In places like Paris or London or New York, if you file a motion in an arbitration, you can expect to be heard same week or following week, with a ruling coming in first, probably from the deck, from the bar, from the bench. Before you leave the room, judge says, these are the interim orders I'm making to preserve the subject matter of the arbitration. Here, I think we have not done what we should have done. I hope we are working to getting there, which is, we should have created a proper, first, when we first mooted forming a commercial division of the High Court, and we were supported by the World Bank a lifetime ago, you remember? The idea was that judges of the commercial division are specialists, and that they would be trained and retrained so that they would be experts. Today, the judge who was hearing civil matters in Murang'a or Kitui or Embu or wherever, for my old students, I used to amuse them with a small station that was called Kasipul Kabondo. But there is no high court there. He will be brought to Milimani, commercial division. Monday morning, first order of business, an insolvency hearing. Ati who? Inso who? So what has happened here? Oh, so what am I supposed to do? I mean, already we are in the wrong court. We promoted a state counsel who became a judge, who had been very distinguished in the line they had worked in, very far away from criminal matters. And her first hearing was a murder plea, and her first order of business was to tell the clerk, Mr. Clerk, please bring me the murder act immediately. Bring me the murder act immediately. And the clerk was trying to cover up her exposure, quickly runs up to her and says, my lady, there is no murder act. So I do think that investing in a true commercial division is in the best interest of our country. And in the commercial division, there should be a subdivision on arbitration and related application. About enforcement, how to arrest an arbitral process that is gone rogue or shouldn't have taken place, or how to deal with the issues of enforcement and so on. And as long as we don't do that, then the process is not efficient. So ladies and gentlemen, I want to wind up my remarks by saying, in Kenya today, in our region, in East Africa, commercial matters are being resolved largely by arbitration. Even our neighbors who were very reluctant to go this way, if you do your desktop research, you will find that all our neighbors have brand new arbitration statutes, brand new, because they all appreciate that this is the future. In our region, Mauritius has been the best forum for many years, and now we are fighting to get a piece of the cake, and I think we are getting there. Rwanda, and I've been to the Rwanda Arbitration Center several times, It is very well promoted, very well. But the truth is that ultimately it's about human capacity, and that human capacity can only be built over a long scale. So Kenya still has a very distinct advantage, and I hope that when people like myself step down from the podium, it is to allow you to step in a very well-developed professional setting where arbitration will be, you'll be able to live a full professional life, doing nothing else but arbitration. It will give you the same satisfaction as people who do environmental matters, land matters, other criminal matters, family matters, other specialties do. I'll stop there. And I don't know whether, Dean, you would like me to take a question, or that is the end of the matter. Mr. Talley?
Thank you, Prof. I think we can take a round of two or three questions. Perhaps one from this side, one from this side, one from this side. Right? We start here. Anyone with a question with respect to the presentation? Do you have a mic? Just state your name and you ask your question. This might be an opportunity, you never know.
Thank you very much. Good evening, everybody. My name is Fukrudin Hassan. Thank you very much, Professor Gidu Migai. My question will be, what will be the actionable blueprint for the Kenyan judiciary to follow, if there are any, to dispose of arbitration matters efficiently? Because from your very long and brief lecture, if I will say in mixing them, it was very clear that indeed we don't have expert judges in disposing of commercial matters which involve arbitration in the Kenyan courts. And of course, the return time as well as what it takes to dispose of those arbitration matters efficiently. Thank you.
Thank you, Mr. Hassan. We can just take the three questions, Prof, and then you will answer together. Yeah. Good. Yes, sir.
Yes, good evening. My name is Shalom Amondi from JQuat. And my question is, it's in regards to arbitral awards. I wanted to ask, how do we prevent an over-judicialization of arbitration, of arbitral awards, in light of the Supreme Court's ruling in U2 Agrovet?
Thank you, Mr. Shalom. Now this side, it's your chance. Someone from this side? We are good? Oh yes, we have one there.
Yes, my name is Richard Tunje, and I have one question from JQuat, and I have one question. How is this decision or conclusion of arbitration being made legally binding between the parties so that they can respect this decision forever in their life? Thank you.
Thank you very much, everyone, for the questions. I will let Prof respond.
Okay, to Hassan, how do we promote the efficiency of the judiciary? I think we go back to first ensuring that the judiciary is properly resourced. That is to say that we have a dedicated registry that whether you are talking about the support staff, that is the clerks, for example, they are well trained. The registry is well computerized. Documents are well received and stored and are retrievable. And then we come to the judges, that the judges are sensitized to the question of why arbitration has special timelines and why we need to expedite. So maybe I would even be happy myself if we didn't have an entire subsection for arbitration, if we had a course list on one day only to begin with. Say Friday matters on the course list in commercial court are arbitration related. So that way you can move a lot of the matters. Then as the demand grows, we can then set up a subdivision for it. But I repeat, in all the major arbitration centers of the world, from Shanghai to Hong Kong to Paris. By the way, a lot of English-speaking people go to Paris also, because the Paris court is very efficient. You are as efficient as an arbitration center as your commercial courts are, because there are many court interventions in arbitration that require to be resolved timeously. Which brings me to the last question before I go to the second one. How are awards made binding? It is by the enforcement procedure provided for both in the Arbitration Act and in the Civil Procedure Act. But in terms of international arbitration, I'm happy you asked me this question. Arbitration is the preferred mode of settlement of international arbitration because of a treaty called the New York Convention, which means that if I arbitrate a matter in Kigali and I get an award of the High Court of Kigali and it is sealed, I can then enforce it in any other country which is a signatory to the New York Convention, which makes life very, very, very simple. So all you have to do is conclude the dispute, go to enforcement to the High Court, get a High Court certification, and then take that judgment and go to the country that you believe the assets of the defendant are to be found and register it as a judgment of that court. And now you can enforce it in that court. And that's why many of us here in Africa, before we professionalized defending these claims, the government would be served with some papers, and it would be thrown from ministry to ministry to ministry. And one day, everybody is trying to run away. Yeah? Everybody is trying to run away from bad news. That is how we got into the Anglo leasing problem in the first place. Because when the Anglo leasing contracts were concluded, and when they went belly up, everybody who had been near them scattered for cover. And one of the ways they scattered is pretending that there were no international cases being prosecuted relating to those contracts. And a decade later, when we said we wanted to issue the Eurobond, everybody who had an old judgment dusted it up and said, let us go to London. And they came from all over the world to London to say, please enforce our judgment against the Kenya government, which we obtained in the Geneva courts 10 years ago. And then everybody woke up. Not everybody. Those who needed to wake up woke up, and the rest is history. There was complete and total chaos. Now, that's what most African governments do. They run away. They pretend these cases don't exist. Everybody goes to sleep. Everybody says, by the time they come, I will be in retirement, which is true. Many people are in retirement. Then what happens? Kenya Airways flies to Rome. And the next thing you hear is that Kenya Airways is not coming back because there is the judgment, there is an attachment warrant of the High Court in Rome against the assets of the government of Kenya, Well, that's true of some of our neighbors where the aircraft is owned 100% by the government. Kenya Airways, as you know, has other complications. So that is how an award is made binding. And that's why it is important that the courts should be part and parcel of the arbitration process. Because without the court order, you won't have an attachment order. Now, Mr. Omondi asks, well, we are worried about the judiciarization of arbitration. But the Supreme Court and Newton and Aggravate seem to do exactly that. And my own thinking there is that the Supreme Court has been also on a learning curve. I think Newton was a bit too far, was a swing to the right. And the Supreme Court has been correcting itself. It discovered that it had opened a Pandora's box, which was not in the interests of anybody else. And I think the Court of Appeal, which ordinarily would be seized with such matters, is beginning to make the door even narrower and narrower and narrower. The true rule of arbitration worldwide is that court intervention is the exception, not the norm. Court intervention is the exception, not the norm. If a party fails to appoint an arbitrator as directed by law, you can go to court and ask, let the court, whatever the default, whatever is. Or if a party goes to court to litigate the matter, when the contract says we arbitrate, again the court can intervene. If there is mara fides in the hearing of the matter, again there may be cause for that. Setting aside is court business. Award, confirming the award and creating a decree is court business. Thank you so much. Dean, I want to assure you, if you invite me again, I will come. And thank you very much for being here this afternoon.
As we come to a close, we will present the gifts. In appreciation to our chief guest, and in appreciation to the young man who has two names which are similar, Israel Tali. We have some tokens here of appreciation, and we again thank you very much for finding time to be with us and to make this particular public lecture a success, which it has been. So I will request Israel Tali to come to the podium. We thank you very much. I then humbly request Professor to come to the podium. Israel, you will deliver this to Chelagat, and you also thank her for a job well done. And you can take a photo on her behalf.
Hello, Daystar. Good evening. I'm really delighted to be part of this today, and my work here is very simple, to just appreciate you for being part of this lecture. It could not have been as it is being concluded in this kind of tone. We couldn't be saying the same words if you had not made it here. Thank you so much, especially I start with the audience. Thank you so much for behaving in good decorum and also making sure that you followed the lecture, you took notes, you asked questions. And for me, I had to break the protocol because I think without you, this public lecture could not have happened. Thank you so much, especially students from other institutions. We have representation from African Nazarene University. Where are you? Can I just see with a wave of hand, where are you? Great, so they came in a good numbers. Thank you so much and welcome to Daystar again and again. We also have representation from JQuat. Can I see where you seated? Ah, nice, we have big numbers. Thank you so much. And of course, the Daystarians, where are you? Ah, nice. Now, as we conclude this lecture, I would like to thank you, Prof, for coming. I know we have not had much of time to interact. I remember one time when I was asked, I was in a law firm, CMS Dali in Amdar. And then we were battling, who do we pick as an arbitrator in this matter? And then we had to settle for Professor. And we were like, he's the best. So indeed, as our dean had already said earlier, you are one of the very best. We can say we are proud to have you amidst us. To our school administration, we really thank you for helping us to put all these pieces together. The support from the technical teams, the live stream team, the corporate affairs team, the office of the Vice Chancellor, and all the protocols that have made this reality. I really thank you. Thank you, Law School Administration, especially our Dean, and our HOD, Public Law, Dr. Olo. We have also other faculty members who are present, and I think at the beginning we never had an opportunity to see them. Just from where you are, the faculty members. We have faculty members who are present. We have Dr. Benjamin Musau. You've heard him. He's a student. Our guest speaker said he taught Dr. Benjamin Musau. We also have Mr. Mutia. He's also among us. We have Mr. Ekiru, who is also in our midst. And then one last thing that I want us to take home is that as we are looking for an alternative dispute resolution, we can as well make ADR as the not the alternative, but the place to start arbitration, or rather the place to start to solve dispute. And instead of making an alternative, let's make it a real deal, okay? There is a lot to explore within this area, and as our guest speaker has told us, we should go beyond just practice in these traditional areas of law, practice as it has been. Allow me to conclude by making one announcement, and then I will invite Israel Tali to make another announcement. So we have announced, my announcement is on with regards to the refreshment. Immediately after this, we have...
According to the bench, impressed, and I would represent the school. We have Kim, Caesar. You can just come for... it was the guy with the mathematics. Prof said you have to know economics and accounting. So he was good. We have Wycliffe Kamau. And we have Nigel Agai. I wish you all the best. I'm available. Should you need any training or coaching, I'm always available, and I wish you all the best as you proceed to represent the school. Come back confirming that we chose the right team. Thank you.
Thank you very much, Israel. We can appreciate him better. And I want you also to appreciate this team. Yes? Yes. Let us appreciate again the team that has made it to represent our name. What I can say, the journey has just started. It's rigorous, you know me. I demand results. And with this, we are taking our Daystar flag to India. It must count. It must count, okay? But congratulations for your selection. Thank you very much. With that, allow me welcome Hanifa to close with a word of prayer.
Let's bow our heads for the prayer. Everlasting Father, we come before you this evening with thanksgiving in our heart. We say thank you, God, for the gift of life. Thank you, God, for the public lecture that we've just had. You started with us, oh God, and we pray that whatever that has been imparted in our lives, oh God, that you'll be able to help us to use it wisely. Thank you, oh God, for the speakers that we've had. We thank you for Professor, for Israel, for Chelagat in absentia, oh God. Thank you for our faculty. Thank you for administration. Thank you for Daystar as a whole, oh God. Thank you for the blessings that you've accorded us, oh God. This day being a success, we're not going to take it for granted. And we thank you, oh God, for the visitors that you've brought to us, oh God. We pray that as a school of law, we will continue growing to serve you and to work for you, oh God, that may our destiny impart the world, not just here, but internationally, oh God. Thank you for each and every person that is represented here, be it a student or a lecturer, oh God. We pray that our destiny in terms of legally, oh God, we pray that it is blessed, oh God, that our future is so bright. And we pray, oh God, that as a whole, you'll continue binding us with cords of love that cannot be broken. We also thank you for the snack that you're going to have, oh God, and the tea, that you may bless it and sanctify it as you're going to take it. Thank you for the journey. Blessed evening.